Okay, hello everybody. My name's Belinda Lambert. I'm from the Consumer Credit Law Centre, and today we're going to be covering mortgagee possessions. In simpler terms, what we understand in the wider society as home repossessions. So my name's Belinda, we have Dara in the room, and we'd like to give special acknowledgement and thanks to Susan Lilley, a financial counsellor who unfortunately couldn't be here today, who has also contributed towards this presentation. So what will we cover today? We're going to cover the terminology that we find in home repossession matters. We're going to talk about what home repossession means. We're going to talk about the 5 stages of the legal enforcement process relating to home repossession. So we're a lender, the mortgagee wants to get a possession order and take legal enforcement action for somebody who is in default and not paying their mortgage. At the end of each stage, we're going to have a case study for discussion, and that will be an opportunity for us to break into smaller groups to discuss Mr. John Smith, a hypothetical client that's coming in to see us to see what are our possible options, and we'll also break at that time to give you an opportunity to stand up and have a stretch before we move into the next stage. At the end, we're going to talk about some common issues with possession matters and give you an opportunity to ask any questions. So when you have a client who comes in to see you with mortgage stress, how many of you have had a client who has come to see you who is in mortgage stress? So a lot of you here today. How many of you have referred your client to a lawyer to get legal advice? What do you think your client might leave with when they've been told that they've been referred to go and see a legal practitioner? What do you think that might be going through their mind? Yes, they're going to be quite concerned with, are they really going to be able to keep their house? And from time to time, you're going to get the client who thinks, when I go and see a lawyer, that's going to translate to mean I'm going to keep my house plus get compensation. There's been a grave injustice. This is my home you're talking about, quite an emotionally charged area. So managing client expectations, every case is different, of course, so we can't say that every case has poor prospects, but managing client expectations is really important, and we just wanted to introduce that first off. So let's talk about some terminology that we deal with in mortgagee possession matters. Who is the mortgagor? The mortgagor, yes, is the mum and dad or the borrower. The mortgagee is the lender. So when you hear mortgagee possession, it's the lender seeking an application for a possession order. Sometimes you'll hear the terminology registered proprietor. What does that mean? Yes, the owner of the house. The registered mortgagee. Yes, so the bank or the lender who has registered their mortgage interest at the Lands Titles Office. We have a Torrens title system of land registration, but we won't go into that because that's quite complicated and all about real property law. The mortgage itself is the loan agreement where the house or the property is the loan security. If the mortgage is unpaid, remains unpaid, so if a client defaults on making a mortgage payment, what is the legal enforcement recovery process for that lender? They can sell the house and use the proceeds to pay out the loan. Another term that we often find in mortgagee possession matters is service. So talking about whether a client has been served with a particular court document. So as we move through the stages, we're going to talk about what a summons is, because the start of the court action is where a client is served with a summons, and service is a term that you will see used from time to time then. So what is home repossession? That's where the mortgagor the borrower hasn't paid their mortgage loan for a certain period of time. So they've defaulted on a loan repayment and they're remaining in default, giving rights to the mortgagee to take possession and sell the property to satisfy the debt. Of course, provided certain requirements are met. We do have some protections in legislation. But essentially, what are we looking at with mortgagee possession matters? We're looking at the right of the mortgagee, the right of the lender to sell the property, and those rights come from the mortgage loan agreement itself, as well as found in legislation. So those rights also come from statute law. So legislation also gives the lender the right to apply for the possession order and exercise a power of sale. What is the crucial key, though, to assisting clients who present with mortgage stress? Something that we experience at the Consumer Credit Law Centre, and you might experience this yourself, the earlier the intervention, the better the outcome is likely to be for clients. So I guess this raises the question, are we asking the right questions early enough? So when a client is presenting, are we asking those right questions to identify whether they are in mortgage stress? Because the earlier the intervention, the better. A client might come in presenting with concerns about a creditor who's contacting them, so debt collectors, and in the background they've got a mortgage that they haven't been paying. So we need to ask the right questions as early as possible to see whether a client is in mortgage stress, and if a client hasn't made their mortgage payments, then this should be the first priority. Why? Because it's their roof, and also because early intervention is the key. Just to put it out there, how many challenges to an application for a possession order do you think are successful? Not many. Yes. So unfortunately, our experience has been that not many clients find themselves in a position where they would have great legal merit to challenge any application for a possession order. It's heard in a summary hearing, so it would have to go into a general list, but in many cases, clients are very limited with their defence. We're going to talk about what sorts of defences a client may have a bit later today. Have you got any examples of where somebody has successfully fought off a summons for a possession order, or any success stories? Yes, do you want to perhaps share? Mm-hmm. So in some situations where a client is experiencing temporary financial difficulty, or where they can actually turn things around quickly and recover, accessing superannuation can be an alternative to look at. Mm-hmm. Yes. So that's a great point you raise. People who find themselves in financial difficulty because of a relationship breakdown and joint liability. So we'll talk about that at the end when we're talking about common issues that we find with possession matters. But I can indicate with some statistics. So court figures obtained through freedom of information. It's very difficult to get an exact number. These statistics are often hidden because there's a fear that if these figures get out in the community, then that will unsettle the property market. But freedom of information laws show that 134 people had their homes repossessed by a warrant of possession. So that's very late in the process, where a sheriff has actually attended the home and evicted the homeowner in South Australia. So these figures are from the South Australian Supreme Court. So 134 people were forcibly evicted or received a warrant of possession. We're going to see in a moment where that fits into our 5 stages of legal enforcement process. So it's quite late in the stage. So this figure doesn't capture those people who have been served with a summons and agreed to sell their home. These are the people who have hung on to the very end. Then we've got 128 in 2012 and 123 in 2011. To give you an idea, there are about 1,600 civil court actions filed in the Supreme Court every year. So we're looking at approximately, just estimates, just under 10%. So that's quite high, I think, of how many warrant of possessions there are if we compare that to how many court files there are for civil matters in the Supreme Court. In last year's annual report produced from the Courts Administration Authority, that's showing that there is a trend increasing where sheriffs are required to forcibly evict people or assist mortgagees execute and enforce a possession order that has been granted in their favour. So the annual report says, while the overall lodgements have decreased, workload has increased in other areas, such as an increase in the number of warrants of possession of property being issued when properties are not being vacated in the time frames ordered. So there's a suggested trend here that mortgagors, borrowers are not vacating at the time, which is quite unfortunate because that will just escalate the legal enforcement costs. So we'll see what all this means once we look at the 5 stages of legal enforcement. So the very first stage is default. What do we mean by default? Yes, a client hasn't made their mortgage payment on time. The client has missed their mortgage payment. The next step in the legal enforcement process is when the client is issued with a notice of default, when they're served with a notice of default. The next stage in the legal enforcement process is where the client is served with a summons. Sometimes this summons is described as a summons under Section 17 of the Real Property Act. Then the client is required to attend a court hearing. Sometimes clients will appear, sometimes they will not appear. My experience in the Supreme Court has been that maybe 50% of defendants are appearing. After the hearing, and there might be a number of hearings, the matter might be adjourned to another date, but if some agreement has not been entered into between the parties, then a possession order will be made by the Supreme Court. And if the client or borrower doesn't vacate the property in the time prescribed in that possession order, so they'll be served with a possession order if they don't vacate, then the mortgagee's next step is to seek a warrant of possession. So where they ask court registry to effectively give them a warrant of possession, which is what the sheriff can use to execute that possession order. And that's where we find a forced eviction. And the last stage is sale. So where the mortgagee is actually exercising their power of sale, so they're appointing a real estate agent, engaging contractors to clean up and sell the property. So as we move through these critical stages, we're going to go back and remind ourselves where we are in this flow chart. So another way of summarising what we've just covered, stage 1 is notice of default. Stage 2 is the service of summons and possession hearing or hearings. Stage 3 is when the possession order is served. Stage 4 is the warrant of possession and eviction if the property is not vacated. And stage 5 being power of sale. So now I'm going to talk to you about stage 0, default. When a client is presenting, they haven't made their mortgage payment, but they have not as yet been served with any notice of default. Something we need to, I guess, try and encourage our clients not to do is bury their heads in the sand. The worst thing that they can do is avoid the matter. And here we have some slides. Denial ain't just a river in Egypt. And as we've spoken about already, a home is so intrinsically part of the Australian identity. It's so emotionally entwined that it can be a very difficult conversation to have, and introducing the prospect of what somebody's options are can be at times quite a distressing conversation for you as well as the client. So what happens if a client has come to see you and they have had difficulty paying their home loan, but they have not as yet been served with a notice of default? This is quite rare and a great opportunity to take advantage of the situation and get that early intervention in. One of the key things though that we really need to establish is, why is our client in financial difficulty? Is this a permanent situation? So has our client suffered some form of disability or impairment that they're not going to be able to recover from? Have they had some kind of injury like a stroke and they don't expect to go back to work and they don't have any other insurance? Or have they experienced job loss and they're experiencing significant long-term unemployment? Or are we dealing with something that's a bit more temporary in nature? Are we dealing with short-term illness where a client has been out of work for a short period of time but expects to go back? Or are we dealing with a client who has been unemployed but expects to go back to full-time employment or back to the employment that they previously had? If we're looking at a permanent situation, what should we be doing? If a client's presenting, so if it's a permanent situation, and say if the client's presenting and it looks like they're going to be on the pension from now into the foreseeable future, and when we do an income and expenditure statement, we can establish that there's going to be a deficit. They're not going to be able to afford the mortgage. What should we be doing in that situation? If we were looking at accessing their super, what sort of things should we be looking at to have in place? If we don't strategise properly, we might get to a default notice. Yeah. Looking at whether a client has insurance that they can claim on. Yes. Yes. So looking at whether they have insurance, whether it's attached to their super. I guess if we're looking at accessing early release of super, we have to be really careful that there is something that's going to come into place to provide them with enough income that they can afford it. So accessing super where their prospects are not viable wouldn't be a great idea. Mm-hmm. Yeah, so it might be individual case to case, so we really have to work out, can this client afford the repayments moving into the future? And often what you'll have is a client who is quite resistant to the idea of change because they've got some underlying trauma that's happened, and to talk about one option being sale of their property can be very distressing, particularly this early on. But for somebody who's in a permanent situation where they're not going to be able to service their mortgage, the earlier you talk about it, the better it is for that client. So what can sometimes be a really useful strategy is talking about preserving a client's equity, working together to preserve their equity, not seeing their equity thrown away on legal enforcement expenses and unnecessary accrued interest and unnecessary default fees and charges. So it's important to see if a client is insured for themselves, and this is an important point to talk about the difference between lender's mortgage insurance and the client's own insurance. Yes, so lender's mortgage insurance protects who? The bank. And if there is a shortfall, the insurance will pay out the bank, but then the insurance company is going to chase after who? The client. So sometimes it's important to, if a client does present and say, I'm fine, I've got lender's mortgage insurance, I paid for it because the client pays for it at the establishment of the loan, client might be mistaken that that's protecting them when really it's protecting the lender. Yes, so some people aren't aware of what insurance policies that they hold, so this is a good opportunity to explore, is there any insurance that the client has? A client might have seen a financial planner, they might have something like trauma insurance, or they might have permanent disability insurance, which might be accessible. If we're looking at a permanent situation, it might be ideal to work with some grief counsellors, because sometimes the client will think that they need financial counselling advice and legal advice, and sometimes it can be more the devastation of having to transition into a new stage in their life. Of course, at this early stage, we shouldn't forget to ask ourselves, is there a responsible lending issue? Is the client unable to pay their mortgage because they should never have been given the loan in the first place? Was it an unsuitable loan contract? If, however, a client is presenting with something that's more temporary in nature, so they're facing short-term unemployment, or they've broken their leg and they expect to make a full recovery, or somebody's ill in the family where they've had to take some time off to care for that ill member of the family, but expect to go back to work, then you might want to consider a variation. Quite important to make that variation request early on. A variation can include a number of different terms, whether you're seeking, on behalf of the client, reduced payments, or whether you're seeking a moratorium of payments for a period of time, whether you're asking for any arrears to be capitalised, and this may or may not include a loan term extension. So sometimes an option is to ask that a client only pays interest-only payments, which falls into our reduced payments. But any variation proposal you seek, it's really vital that it is realistic. One of the common mistakes we see a lot of our clients make is that they're under so much pressure to get a variation agreement that they agree to something that they just cannot afford and is not realistic. The last thing we want is a client to breach their own variation agreement and then move into that next stage of legal enforcement, the notice of default stage. So any variation proposal must be realistic, something that the client can meet.
Okay, so now we're going to talk about the notice of default. This begins the very serious part of home repossession. So the notice of default will arrive when they're in arrears. It usually gives them, it's quite a comprehensive letter. It'll often be on a law firm's letterhead. It tells them how much they're in arrears. It tells them they've got 30 days to fix the arrears. I think there's also nowadays also a requirement that there be some reference somewhere in there to financial counsellors, that they can get financial counselling assistance, and there's the 1-800-007-007 number for them to contact. So, of course, the problem is that for many clients, this is where they stop reading anything that comes from the bank, and they don't turn it over to look at that useful information about contacting a financial counsellor, but it is there. So basically the notice of default gives them 30 days to clear the arrears, make the next payment. I'm sure you're all aware of that. If they do manage that, that's called redeeming the mortgage, and essentially they start over. So all is forgiven, and the process, if they fall into arrears again, will have to start over. So if they can't pay the outstanding arrears and the money that falls due, it tells them in the notice that where it's available in the mortgage contract, the bank can accelerate the loan. That means the loan becomes immediately due and payable. So we've given you a default notice. Hopefully it's even smaller on there, so you can't read it. But anyway, that's what they look like, or should look like, something along those lines. And all the information that I've told you is there. How to pay, the property. We have had clients come to us where there have been errors on the default notice. Whether or not that has ultimately any bearing on their matter, it probably doesn't, especially if it's something small. But do check and make sure it's the right property, the right person. People who are in arrears generally know that they're in arrears, so the little things on the default notice are not their greatest concern at the moment. Next one. So the point at this period is to, once again, as soon as possible, begin negotiations with the lender on behalf of your client. So the options are similar to what they were before they got the default notice. So you're going to try to develop some sort of plan, something that's reasonable, sustainable, and something that can be sold to the bank, to the lender. Why this is important now is because costs are going to start mounting. So already sending the default notice has cost your client several $100s because usually it's a solicitor that's taking care of it, or even if it isn't out of the, it hasn't been out of the bank, it's in-house, it's still charged to your client. It's $500, $400, $300-400. So again, it's one of those things. On its own, it's not a lot, but when you add it to all of the other debts the client has, it's something you don't need. Now, once it goes to a summons, there is straight off the bat $3,357 filing fee in the court. The bank pays that, but ultimately it gets charged to your client. It's not generally something that's negotiable. It's not something the bank is going to waive unless it's something that the bank has done in error. So keep in mind that is only the filing fee. There'll be other fees on top of that if there's solicitors involved, and there are always solicitors involved. Next. Yes, so if you're in this process and it doesn't look like you're going to get an agreement from the lender by the end of the period, go to EDR. EDR will stop the possession action, so the lender won't be able to go to court, and it will give your client some time to discuss their plan with you, time to get legal advice, but of course the most important thing is that it will stop all legal action for the period that it's with the Ombudsman. So, as before, you want to clarify the reasons before the default. You want to know, most important thing to know, is it temporary or is it ongoing? If it's temporary, of course, your options are much broader. When you're negotiating with the bank, there really is no rule as to what you can negotiate for on behalf of your client. So you can think outside of the box. It doesn't have to be A, moratorium, or B, extended period of loan. You can do combinations. If you think of something else that would assist your client and the bank can agree, the bank is only interested in getting their money. So they'll go without getting the full amount for a certain amount of time, as long as they can see in the future, preferably shorter term than longer term, that they're going to be able to get all their money. So there, again, just these are the most common things that we negotiate, that we see also in negotiations: reduced payments or moratorium on payments, capitalizing the arrears, and or time to sell the property themselves. Can you go back, sorry? Back arrow. One more. Okay. Just because you've negotiated one agreement doesn't mean you can't negotiate another agreement. But the first agreement generally has to work, or you're not going to get, you may not get a second chance. So, as Belinda said, don't allow your client to enter into an agreement if you don't think that they can maintain it, as if you can stop them. I mean, ultimately, it's their decision. But as Belinda said, we shouldn't be enabling them to enter into an agreement that they can't maintain. But if they are able to maintain an agreement for that 3-month period, 6-month period, and things haven't got better, but they're still optimistic, there's still a chance, they have a job interview, or auntie is really looking dire, then negotiate again, contact the bank. The important thing, as I'm sure you're all aware, stay in contact with the bank, let them know what's going on, don't let the client lose touch so that the bank thinks that they're forgotten and that their money's forgotten. So as I said, something we find the banks really like is they will do a 3 or 6 month agreement, no payments or minimum payments, and if they're making minimum payments at the end of that 3 or 6 month period, then the bank are more likely to enter into, or more likely to allow a capitalization of the arrears. So if your clients have shown themselves to be a good risk, then you're much more likely to get some sort of satisfaction at the end of the day. So this is kind of a technical issue. It's essentially telling you that you've got a little more time than the default notice if you begin negotiations to enter into some sort of variation. So essentially, you can get an extra 14 days. So let's say at the end of the 30-day period, let's say on the 29th day, the bank has agreed to, or you've put forward a plan to the bank, and they're going to look at it. That essentially gives you 14 extra days that they're not going to push for enforcement. Same thing if you want to request a postponement. You've got that extra time frame.
So where you can, trying to avoid that where possible. So requesting a postponement for commencement of any legal enforcement action. If you do that, then the lender has to wait 14 days after giving notice of their decision not to agree to any postponement action before they can file. And in that 14-day period, you then have time to go to the Ombudsman, if you need to get some time. And in that time, if it is looking like things are not going to improve for your client and their financial situation is looking permanent, some difficult conversations need to be had. Because if you're going to give the client false hope that through the Ombudsman process, the Ombudsman is going to say, yes, you're entitled to a variation, and the outcome is if they were to proceed right through to the determination and they weren't successful in that hardship variation, what have they effectively done by prolonging or protracting this? They've just accrued interest and their equity has depleted in that time. So, so long as you're quite strategic in working this for your client's benefit and not enabling them to make their situation worse. Okay, so we'll move into stage 2, which is when a client is served with a summons. So a client, in most cases, is personally served with a summons. Because this is the very beginning of the court proceeding, a client is required to be personally served, so a process server will personally serve them with the documents. If a lender is having difficulty serving a client because they're trying to evade service, if they know that they're in arrears, they can sometimes get other orders to serve them through somebody that they know or a known email address or at their last known place. So sometimes clients call us and say they served my child. But essentially, this stage involves a client being served with a summons, which means it's already been filed in the Supreme Court, so we're already $4,000 to $5,000 behind. In the hearing, so a summons is, I guess, asking a client to attend a particular court hearing. So there's a court date on that summons, and we'll look at what a summons looks like in a minute. But it's what we call a summary hearing. The court is not going to proceed in what we call a trial. The court's not interested at this stage in hearing a client's defence. If a client does raise a defence, so if a client starts talking about, I want to make a section 72 or 74 application for the court to make an order for a variation, or this is an unjust contract under Section 76. If they start going down the defence lines, then the court will put it in an ordinary list. But at that summary hearing, the court is only going to make a decision whether or not to grant that possession order on that day or adjourn the matter or dismiss it. What is the court looking at? That the client or the debtor, the mortgagor, has defaulted. They have to be in default for more than a calendar month or 30 days to be served with the notice of default. Once they've been served with the notice of default, then in that time of the default period, the arrears have not been rectified. So it's remained in default past that notice of default period. The court is also concerned with whether the notice of default has been properly served so that all the requirements are met. They're all legislative requirements, and we didn't want to tie you down and bore you with different sections of different acts. And that the client hasn't paid before the notice of default period has expired. That's all the court is essentially looking at. Tick, 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 bang. From a legal enforcement process perspective, the lender is then entitled to a possession order. However, a possession order hearing cannot be served until at least 16 days have passed since the mortgagor has been served with the summons. So sometimes a client will attend court and they'll say, oh, they adjourned it because there was not enough time between when I was served and the hearing date. So if a process server is having difficulty finding a client or serving a client, this can potentially happen. But it is a summary hearing. Typically what we find is the court will entertain an adjournment in the first hearing. If a client says, I haven't got legal advice or I haven't got financial counselling advice, but it all depends on the history of a matter, what the loan to value ratio is. Every case is unique. Good question, does the client have to attend court? Consumer Credit Law Centre will always strongly advise a client to attend court so they know what's going on, particularly if a client has filed a dispute with the Ombudsman or has applied for a hardship variation, just to make sure that there has been no breakdown in communication, to make sure that the solicitors acting for the bank haven't missed something in the loop. Because when you're talking about a large bank, there can be many departments, and so you're relying on all these people to communicate with each other, and sometimes if the client can just keep their finger on the pulse, that will prevent any mishaps from happening. We would always advise a client to attend, but 50%, I would say, of matters heard in the Supreme Court are there's no appearance, there's no defendant. This is what a summons would typically look like. It is pages long because you also have an affidavit attached to it, but typically this is what it may look like if a client brings their court document in. Do you want to flick the page? And so you'll see here the summons says something along the lines of the plaintiff bank is seeking an order for possession of a particular property, and the summons will outline that the court is going to hear this application for the possession order, and it will also give details of when the court hearing will be heard, the date and time, and the place. If a client has filed a dispute with the Ombudsman and is not quite sure whether the hearing's going ahead or not, the client can check the Courts Administration Authority website the day before the hearing to see if they're on the list, or call the Court Administration Authority on 8204 2444 just to ask, I have been served with a summons, I was listed for this date, however I filed a dispute with the Ombudsman, I'm just checking to see if my matter will be heard still tomorrow or not. If the court says yes, it's a good idea for your client to go, just to make sure the court is advised that a dispute has been filed. To let the judge know, which would then mean if a dispute has been opened, no order for possession will be made, which will give your client a bit more bargaining power when they're trying to negotiate with the lender. But when we see a client who's presented after they've been served with a summons, again, we need to act quickly. We need to act quickly, this time before the court hearing date. Again, we're looking at, are we looking at a temporary or permanent state of financial affairs? Nevertheless, there's still opportunity to negotiate. Depending on what the client's particular circumstances are, will ultimately dictate what is realistic. So, what is the history of this matter? Has this client had a series of hardship variations that they've breached back to back and the relationship has completely deteriorated? Or are we dealing with somebody who had no idea that they had this right to ask for a hardship variation and had no idea that there was an ombudsman in place? Those two clients will be very different. If time is short, then it's a good idea to file with the ombudsman. This just puts a stay in legal enforcement processes, but also gives the client the ability to have the ombudsman assist them facilitate a variation agreement. Okay. Again, if it's temporary, we can look at options such as capitalising arrears, asking the lender to capitalise arrears, looking at whether we apply to the Department of Human Services, or the client, I should say, applying. But if we are going to access early release of superannuation, it's not a good idea if a client's financial situation is unlikely to improve. We're actually going to make their overall financial situation worse. So if a sale is inevitable, we're best off leaving the superannuation where it is. We can also negotiate payments, and there are various options there. Often clients will say, oh, but I can make the payments. And if that is the case, then they really need to know that now is the time to prioritise these payments if they can make the payments. They should be paying whatever they can. So if it's permanent, change in financial situation, we really need to ask, can the client meet ongoing mortgage repayments? Do they have any other options for generating income? Is their financial situation likely to improve? So can they rent the place out? Can they, if they are looking at renting the place out, we need to look at taxation and Centrelink repayments. If this has been going on for a protracted period of time, maybe we really need to have a difficult conversation with what are our other options if there's no way out. Likely best option in this situation where it's a permanent financial situation, they cannot make their ongoing mortgage payments, is to negotiate with the lender for the client themselves to sell the property. But there are some instances where a client is unable to improve the property, or there are some instances where the client is going to face a shortfall. So even if they were to negotiate selling the property themselves, they might spend all this time and energy to ultimately face bankruptcy at the end. So it is case by case. But in most cases, the best option is to negotiate sale. Now we're running short for time, so I'll move us through very quickly. Advise your client to attend the hearing. It's prudent for the client to check whether the hearing has been adjourned for another date or stayed. And we've got the details of the Court Administration Authority number and the court's website up on this slide. Okay, so if a client has factors for a court to consider, so for example, if the client has already engaged a real estate agent and has a sales agency agreement in place, the court is interested in that. Has the client applied for release of super? Does the client have a contract of sale? Have they already sold the property? The court will be interested in this because they will vary the terms of a possession order to frame around this. A court might be inclined to give an extended time on a possession order to accommodate for one of these things. If a client has applied for refinance, unlikely if a client's defaulting that they're going to be eligible for any finance elsewhere because that's going to be a responsible lending issue, but whether a wealthy family member has come along and said, I'll pay out your loan. and whether a client has filed a dispute with external dispute resolution, then that's something a client should be advising the court in a possession hearing. 3 possible outcomes at a hearing. The court will either grant the possession order. Typically, the standard order is that the borrower must vacate within 14 days from being served the possession order. However, sometimes the court will grant an extended period of time. So if the property is on the market, the judge might ask, how long does your real estate agent think it's going to take you to get a contract of sale? And then the court will entertain an extended period of time for this possession order to take place to give somebody a chance to get a contract and settle before the possession order becomes effective. Otherwise, the court might adjourn the matter, so put it off for another date. That might be to allow the borrower to go get financial advice or financial counselling or legal advice, or to negotiate, or whether it's listed in the full trial, so put in the general list if the client does have a defence, or the court might dismiss it. Sorry, next slide. Sometimes a client will say at this point, but can't I just pay the arrears and this will go away? Will it go away if the client just pays the arrears? No, you're at the mercy now of the bank. Some banks will take on legal enforcement action because they're only really interested in the arrears, and they're happy to negotiate taking payment of the arrears and allowing the loan to continue. But from a legal point of view, can the lender at this point, after the summons has been served, say, bad luck, we want out? You keep defaulting on this, we've entered into a number of variation agreements, this isn't working, we want out. They can. So they can exercise their acceleration clause, but of course our consumer credit laws prevent a lender from accelerating a loan until the default notice period has expired. After the default notice period has expired, then it becomes in the lender's court and domain whether they agree to allow the borrower to pay the arrears and continue on making payments. And this is another reason why it's important to ensure any variation agreement is not breached, to show good faith. Possession order, so that's after the possession hearing. The court has actually granted the possession order. It's normally served personally, and that's where somebody is officially given the possession order and given notice to vacate the property. Normally it's 14 days from being served the possession order, but the court has a discretion to extend that time period. So for example, if there is a sales agency agreement in place. So this is what an order for possession of property looks like that your client will be served with. So we'll tell them that they have to vacate. If a mortgagor does not vacate by a date given in the possession order, this is when the lender goes back to the court and says the borrower hasn't left the property in accordance with the terms of the possession order, therefore can you please issue a warrant of possession? And this is what the sheriff will use to enter the property and change the locks. Personal property, really important for your client to negotiate access to get their personal items removed. Sometimes a client will call and say, I got evicted and I don't know where my belongings are. And sometimes the lender will put it into storage and then charge them. Next slide. So this is what a warrant of possession would look like. And so this is, as you can see, it's directed to the Sheriff of South Australia. You are directed to take whatever lawful steps are necessary to cause the plaintiff, here the lender, the mortgagee, to have possession of the property and dispossess the defendant, here the borrower, of the property. Next slide. So if 6 months have passed since the possession order was granted, then the borrower must then be served with a notice of application for permission to serve warrant of possession. So this is essentially, if the possession order was granted but the lender hasn't moved to get the warrant of possession for whatever reason, then the borrower gets the benefit of being given a heads up, notice that they're intending to seek a warrant for possession, and they're given 10 days to object, but there they would need to have something like their circumstances have drastically changed. If a client re-enters a property after they've been evicted, then that's contempt of court, and they can potentially be imprisoned for 40 days. Unlikely, but that's a possibility. Stage 5 is the sale. So this is where the mortgagee, the bank or lender organises contractors to come along, tidy, repair the place ready for sale, and they will engage a real estate agent to sell the property. This means who is appointing the real estate agent? The lender. So the client loses the ability to appoint somebody that they trust or somebody with local expert knowledge. The client doesn't have possession of the property to polish the taps and make, brew coffee in the kitchen and make the place as appealing as it would otherwise be. Costs associated with preparing the property for sale, marketing expenses and agent fees, of course, are passed on to the borrower, the mortgagor, and the mortgagee does have a duty to take reasonable steps to obtain market value. If there is a dispute as to the conduct of the mortgagee, the bank or the lender with regards to handling the sale, then you can raise a dispute again with EDR but on different grounds. If a client has been forced out of their home and they've left their personal property behind, then the mortgagee has a duty of care to take care of their personal property. But after a reasonable time passes, so if the client just does not stay engaged in the process and they haven't made any contact for months on end, they might find that their items have been regarded as abandoned at law and they've been auctioned off or given away to charity. There may still be an option to negotiate selling a property even after a possession order has been granted. So that still is a possibility, but it depends on the history of the matter and the loan to value ratio. So if it's a low loan to value ratio, meaning the client has quite some equity in the home, the more willing the lender will be to negotiate. So here are some examples of mortgagee sales. Not all agents will advertise it's a mortgagee sale. APRA don't disclose how many mortgagee sales or foreclosures there are because they're afraid of the effect that that will have in lending and in the property market. This is an example just last week of a mortgagee sale advertised over the weekend. So this is a property in Hackham. It's a different number, but I changed the number around. Vintage Avenue, Hackham. If you want to have a look on realestate.com, you'll find an example of a property that I just randomly searched realestate.com, so it doesn't relate to a client, that's subject to a mortgagee sale. What are some common issues with possession matters? We typically find issues with relationship breakdown. So where one spouse has left the home or one partner, and unfortunately clients don't necessarily understand or appreciate that if they're joint borrowers, they're considered to be jointly liable, and so the bank is not concerned with only accepting their half and releasing and discharging that client from the mortgage payments. So it's really critical that they get family advice early on, even if there's a shortfall. So sometimes clients will say, I haven't seen somebody because it's going to be negative equity, but they're going to still have to come to some agreement how to apportion that loss. And community legal centres are a good point there because if they can't afford to engage a private solicitor, they might want to seek assistance of a community legal centre.
It's not a consumer credit matter.
Yes, it's not a consumer credit matter. But the consumer credit component is if a client is presenting in a relationship breakdown and that is causing the mortgage stress, then you might want to seek a variation to give the client an opportunity to negotiate their family property settlement. A bank does not have to agree to transfer the loan into one partner's name unless it's required to do so by court order. But if you look at the main lenders' websites, they will have some great information, fact sheets that they're required to publicise through the Code of Banking Practice on their position with relationship breakdown and family breakdown. So some useful, yes, on the bank's website, so your ANZ and your CBA, they have some great fact sheets there. which are great for your clients, and that also reinforces the fact that this agreement is between the two partners and the bank. The bank is not interested in just taking half, because that's a private arrangement between the two. So we've got this slide, another slide left. Importance of ensuring any variation agreement is realistic, so the client doesn't breach any variation agreement and meet ongoing regular payments is crucial. Because what is a variation agreement? It's another contract. It's a contract where the parties agree to vary the existing contract. You're varying the loan contract, so it's vital that the client doesn't breach the variation agreement. Ask ourselves, is delaying the matter and escalating the dispute to an ombudsman really in the client's best financial interests? So if we're looking at something that has a huge history, so sometimes we have a client present to us who hasn't paid the mortgage for 2.5 years, has been on New Start for 2.5 years, has very poor prospects of turning things around. Is protracting the matter in their best interests? Might be a case-by-case basis. If they're going to face an inevitable shortfall, maybe it's a different scenario than if they've got equity to preserve. Make sure you've got your numbers for grief counsellors and housing assistance referrals. So often one thing that clients struggle with is not being able to move forward. Often a big obstacle is, I got nowhere to go, which is understandable. It's quite devastating for somebody to be in this situation. But giving them resources of where to go, we're happy to provide you with resources we've been given from the Minister's office with housing assistance. The earlier the better. Don't forget responsible lending disputes. If a client is in default, are they not making their payments because they could never really make them? And don't forget to check for our insurance. And remember, lender's mortgage insurance protects the lender, not the client. There is a Money Smart link after this, which I encourage you to log on to. This just, I guess, prepares your client as to what assistance most legal advice will entail. So they're not thinking the High Court and they're going to keep the house and get paid compensation, because sometimes when we interview clients for the first time, we'll say, what are you expecting? And some clients will say, I expect that I'll keep the house and that they'll pay me $200,000 in compensation. So we've got a lot of work to do with expectations. So this Money website has some videos of somebody who is facing mortgage stress because of relationship breakdown, and where the client is negotiating through the lawyer ways to stop or slow down the legal enforcement process so that she can sell the home herself. And that's where we can best help.